Welcome, and thank you so much for joining us today. Today we are sharing with you HR 101 Essentials for Managing Your Workforce, and we are excited to talk to you about all the great things that are basics that your companies need to know. I'm Brittany Pierce, chair of our Ryan Swanson's Employment Rights and Benefits and Labor Group. And today I'm excited to be joined by my colleagues, Kristen Neely-Meyer, Hannah Kern, and Madison Burke. For those of you who aren't already familiar with our firm, Ryan Swanson is a full-service 40-attorney law firm based right here in the Northwest. Each one of us here today are members of the firm's employment group, and we have a bigger group as well. We work with businesses and owners and HR professionals regularly at all levels to help them implement practical, creative solutions to protect their businesses from potential threats that can disrupt their workforce or business operations. Presentation slides are posted on our website as well, so please feel free to go to ryanswansonlaw.com/events to download them.
As Hannah mentioned, I'm going to be talking about proper classification for your workers. So first, what is worker classification? So every employer has to determine whether a worker, a person performing work for the business, is an employee or an independent contractor. And misclassification can carry a lot of very significant penalties and fees, liability, financial liability for the employer. So for example, if an employer improperly classified an employee as an independent contractor, and that was discovered either through the employee reporting to the state agency that they think they're misclassified, or through an audit determining this, the employer could be on the line to pay back taxes, back wages, insurance premiums, penalties, and interest on all of those things for each individual misclassified worker. So this can be a very significant financial hit for employers, making it very important for employers to take the time to ensure that their employees are properly classified. So how do you tell whether your worker is an employee or an independent contractor? This can be a legal minefield because, as we'll talk about in just one moment, there are a lot of different tests, there are a lot of different laws that apply, and each agency applies a various test, and it becomes very fact specific. This is where we, the employment lawyers, can come in handy to help guide you and make sure that you're making that proper classification. But in general, we'll talk about what you need to know as you're making the determinations for yourself. So the most important thing before we get into any of that is that no matter what test is applied, no matter who is auditing you, the presumption is always going to be in favor of finding that your worker is an employee and not an independent contractor. So that's where, if there's any question, you need to keep in mind that the auditing agency or whomever is looking at this is going to lean toward finding that they're an employee. So some of the laws that are at play here, we have Washington's Industrial Insurance Act. This is enforced by DLI, the Department of Labor and Industries. Generally, individuals are determined to be exempt from being considered employees, a long way of saying independent contractors, if they meet all of 6 different criteria that are required. Under the next law, the Employment Security Act, this is enforced by the Employment Security Department, and they have 2 alternative tests that are applied with different factors to determine whether someone is an independent contractor or an employee. And then Washington's Minimum Wage Act, which is also enforced by DLI, but under the Minimum Wage Act, the Washington Supreme Court adopted a test in July of 2012, and that test considers whether the employee, as a matter of economic reality, is dependent on the business to which he or she renders the service. And there are several factors that are applied when a court is determining this economic reality test. So applying these tests, as we mentioned earlier, each test has different factors, and it becomes very fact specific for each employer and worker relationship. In general, the most important factor for you to keep in mind as the employer is the level of direction or control that you have over the worker and the work that they're performing. Where are they doing it? How are they doing it? What are they doing? The more control and direction that you take over those things, the more likely it is that you have an employee and not an independent contractor. So, how do you avoid liability? How do you avoid misclassification? The most important thing if you have an independent contractor is that you have a written contract with them. And in that contract, you're going to want to make sure that you're including all the details, that you have an independent contractor relationship, that this is not an employment relationship, that they're, as you can see here, I've listed a number of factors. They're keeping their own books, they're responsible for paying their own taxes, they bear their own costs and expenses, they're performing the tasks outside of your company and your company's normal operations, and they provide their own tools, their own materials, and then that it's for a fixed period of time. So it's not just an open-ended relationship, but it's for a specific task or a specific period of time. Now, you have to actually follow the contract. So I'm saying it louder for the people in the back. It's not enough to just have the contract. You have to make sure you're actually observing everything that's in the contract. So when you're saying this is only for a specific project or a specific period of time, then if you want to have them for an additional project or additional period of time, you have a new contract for that. If you say they're performing outside of the company, but then they're actually coming and performing in the office, they have an office space. I mean, these are all things that in the end of the day will work against you, circling back to that presumption we talked about that is always in favor of finding that they're an employee, not an independent contractor. So have the contract and then follow the contract terms. So once you have determined that you have an employee, then there's additional classifications that you have to make as an employer. You have to determine whether they're an exempt or a non-exempt employee. Most employees are non-exempt, and the default presumption is that the employee is non-exempt, and a non-exempt employee must be paid overtime. So there are several state and federal overtime exemptions. And I have it outlined here, you can see on the slide. So if your worker is paid a predetermined fixed salary, if the salary meets minimum threshold requirements under the law, and if the duties of the position primarily involve executive, administrative, or professional duties as defined in these regulations, then your employee may be exempt from overtime. In making the determination of whether someone is exempt or non-exempt, the jobs duties test is applied, and that goes to the last bullet that I was mentioning about whether you fall into the administrative, professional, executive exception. There are a couple others. You'll see here, computer professional, outside salesperson can also be exempt individuals. And so this job duties test looks at the actual duties that are performed by the employee. So it ultimately is inconsequential what's the title of the position or what's your description of the position, if that's not in fact what the duties are that the employee is performing in the position. And these rules have recently been updated. So you're going to want to make sure that your exemption or non-exempt classification is in compliance with what the most recent rules are. If they were in compliance with the prior rules, that's great, but it doesn't hold to the past law or the law at the time you hired the individual. It has to be in compliance with the current law. Let's see. Next, so we mentioned as one of the bullets of how you determine whether someone is an exempt employee that they have to meet certain minimum salary thresholds. So we've put here what those salary thresholds are in Washington state. And it's important to note that in Washington, under the applicable law, there's a multiplier. So you'll see for the small businesses right now, it's 1.5 times the minimum wage. For the large businesses, it's 1.75. And this multiplier is actually increasing in a phased in approach over the next 7 years. And so you're going to want to make sure that each year you are looking at what the new salary threshold is for any employees that you have who may have previously been exempt, to ensure that they're still qualifying under this salary threshold. There's different for computer professionals. There's a different requirement. If you're interested in that, or you have employees who you think may fall under that exemption, feel free to reach out, and we would be happy to talk to you about what those thresholds and requirements are. The size of the employer for the threshold, salary thresholds, is based on just Washington employees. So if you're a larger employer across the country or in the region, they're just counting Washington-based employees that are employed as of January 1 of the calendar year. Currently, the federal salary threshold for exempt and non-exempt is remaining where it has been for a while, but and for the first time in history, actually, Washington's thresholds are set to exceed the federal thresholds, but as Washington employers, you have to comply with whatever is most favorable to the employee. So keep that in mind as we're going to step quickly out of sync with the federal rule.